All right, good morning, everyone. My name is Stephanie Fahuri, and I am the director of the Cancer Legal Resource Center. Thanks so much for joining us for everything you've wanted to know about medical marijuana but have been too afraid to ask. Before we get started, just a couple of housekeeping items. We are going to be recording the webinar, and we will be posting it on our YouTube site in the coming weeks. So if you have friends or colleagues that aren't able to make it today, please feel free to share that with them. And I'm also going to do my best to leave some time for questions at the end of the webinar. So just a quick overview for those of you who might not be familiar with the Cancer Legal Resource Center. We are a program of the Disability Rights Legal Center based in Los Angeles, California. And our mission is to provide information and resources on cancer-related legal issues to patients, survivors, caregivers, healthcare professionals, and pretty much anyone else coping with cancer. All of our services are confidential, and we generally do not represent clients directly. The CLRC also maintains a library of fact sheets on a variety of cancer-related legal issues on our website, including a resource called our Patient Legal Handbook. We've actually just released a new version of our Patient Legal Handbook, and we're currently taking bulk orders on our website. So we're super grateful to the American Cancer Society and Breakaway from Cancer for their sponsorship. And if you're interested in ordering copies or downloading a copy for your own personal use, please check out cancerlegalresources.org. We have a couple more webinars scheduled for the rest of the year, and so if you're interested in health insurance, housing rights, or resources for caregivers, please feel free to check out our website as well to register for those upcoming webinars. Now, as I mentioned, I'm going to do my best to leave plenty of time for questions at the end of the webinar. I'm probably going to be speaking a little bit quickly to try to get through all of the material. But if I'm not able to get to your questions, or if you have questions that come up later, please feel free to follow up with us through our website, clrcintake.org. That's where you can submit any questions that you have. We'll do some research on your questions and get back to you with information. So all of the information that we provide is free, but just as a reminder, we do not provide legal advice or direct representation. Today we're going to dive into some information about medical cannabis, or as it's better known here in the US, medical marijuana. We'll be discussing the laws that govern access to marijuana, practical and legal concerns that people with cancer and others who use medical marijuana may have. However, before I say anything else, please keep in mind that the marijuana laws and penalties change rapidly and are enforced and interpreted differently even within the same legal jurisdiction. This webinar does not constitute legal advice. Please consult a criminal defense lawyer in your state if you have been busted, or if you want to know how a particular conduct might be punished. One thing I am not going to go over today is much of the science around cannabis and claims or links to prevention or treatment of cancer, as opposed to possible benefits in treating associated side effects. While there is ongoing research on the topic of cannabinoids as potential anti-cancer agents, I'm not a scientist, and that is beyond the scope of my knowledge or expertise. So a little bit of background. Cannabis is a type of flowering plant, although the flowers don't quite look like most flowers we're used to. Cannabis has long been used for hemp fiber, for hemp oils, medicinal purposes, and obviously as a recreational drug. Industrial hemp products are made from cannabis plants that are specifically selected to produce a lot of fiber. Although the term marijuana is Mexican, the use of cannabis as medicine has been taking place for thousands of years. Classical Greeks and Romans used it. Use spread throughout the Islamic Empire to North Africa. It was transported to the Western Hemisphere by Spaniards who imported it to Chile for use as fiber. And British herbalists in the 17th century also noted its medicinal purposes. It became widely used in British medicine in the mid-19th century. And it's possible that even Queen Victoria might have used medical cannabis. Her personal physician, Sir Russell Reynolds, wrote in the first issue of The Lancet, when pure, this is a quote, when pure and administered carefully, it is one of the most valuable medicines we possess. So if this plant has been used in medicine for literally thousands of years, what has happened to bring us to where we are today? To understand what happened to cause cannabis to go from a plant with respected medicinal properties to, sort of public enemy number one, we need to look at what was going on in the United States in the early 1900s, just after the Mexican Revolution. After the Revolution, immigration from Mexico into states like Texas and Louisiana increased dramatically, since so many civilians had lost their farms or property during the conflict. In addition to bringing with them their native language, food, culture, they also brought with them their customs, one of which was the use of cannabis as a medicine and sometimes a relaxant. The Mexican word for cannabis is marijuana, so while Americans were familiar with the cannabis plant and its uses in almost all available medicines at the time, the word marijuana was foreign. The Marijuana Tax Act of 1937 was then passed, which effectively banned its use and sales. That law was later ruled unconstitutional. A common example of the way marijuana was portrayed in the middle of the 20th century is through the film Reefer Madness. It was a propaganda film, sort of surrounding really melodramatic events that ensued when high school students were pushed to use it. There were hallucinations, manslaughter, suicide. It's a really sort of wild film. Marijuana prohibition and demonization has continued since then, though in recent years some of that has changed. I'll go into more detail about the current legal status about marijuana in the next section. Before we get into the legalities around cannabis and marijuana, let's first get some background on what exactly medical marijuana is. We're not just talking about the use of marijuana for recreational purposes or to get high. The term medical marijuana refers to the use of marijuana or cannabis. I'm probably going to be using those terms interchangeably. So the term medical marijuana refers to the use of marijuana plant or products made from the plant to treat illnesses and symptoms. A growing body of scientific research has suggested that marijuana may effectively treat conditions such as nausea, pain, muscle inflammation, and even epilepsy. Many people who are chronically ill use medical marijuana to improve their quality of life, with results that are comparable to or better than those they experience from conventional medicines. Additionally, Americans now overwhelmingly support fewer restrictions on marijuana, with 86% saying doctors should be allowed to prescribe the drug for medical purposes. And actually, a 2013 poll, so that's already 5 years ago, conducted by the New England Journal of Medicine, found that 3 out of 4 clinicians would recommend the use of medical cannabis for a hypothetical cancer patient. The use of medical cannabis has been endorsed by numerous professional organizations, such as the American Academy of Family Physicians, the American Public Health Association, and the American Nurses Association. So the question is, does medical marijuana work? Well, in 1999, the Institute of Medicine published a report called Marijuana and Medicine, assessing the science base. In that report, the IOM concluded that nausea, appetite loss, pain, and anxiety can all be mitigated by marijuana. For patients such as those with AIDS or undergoing chemotherapy who suffer simultaneously from severe pain, nausea, and appetite loss, cannabinoid drugs might offer a broad spectrum of relief not found in any other single medication. Many currently available analgesic drugs have serious side effects, and they're not always effective in treatment of neuropathic pain, and that type of pain is often resistant to, let's say, opioid medications. One of the most widely studied therapeutic applications of cannabis is in the treatment of nausea and vomiting associated with cancer chemotherapy, and many people receive quite a bit of relief by using marijuana to treat those specific symptoms. However, recently, an Australian research study was published in the Lancet Public Health Journal. Researchers concluded that they found no evidence that cannabis use improved patient outcomes. Those who used cannabis had greater pain and lower self-efficacy in managing pain. The new research study really caused a bit of a stir, and some experts and marijuana advocates have been questioning the methodology or conclusions. One thing to keep in mind about that study is that medical marijuana was only decriminalized in Australia in 2016, and the research had been going on since well before then. So the majority of this study cohort was using and reporting on illegal cannabis use, which means that there wasn't a lot of quality control going on. I'm not a researcher or a scientist, but I think one thing that is sort of clear from these two differing points of view is that there's certainly a need for ongoing research. So how does medical marijuana work, if it does in fact work? Marijuana works in an effective treatment for some conditions because of chemicals called cannabinoids, which are produced by the plant's flower, stalks, and leaves. When consumed, these cannabinoids interact with neurotransmitters in your brain and receptors in your nerve system to produce a variety of effects on your body. There are more than 100 different types of cannabinoids, but most people are familiar with just two: THC, or tetrahydrocannabinol, and cannabidiol, CBD. THC is what produces the psychoactive reaction, or high, that is often associated with marijuana use. CBD, on the other hand, is responsible for most of marijuana's medicinal effects and has been linked with relief from inflammation, pain, anxiety, seizures, spasms, and other conditions without negative side effects like lethargy or confusion. One thing to keep in mind about CBD is that there are a lot of unproven medical claims about the benefits of CBD oil. The FDA, or U.S. Food and Drug Association, has previously issued warnings to CBD producers that claim that their products could treat specific diseases like cancer or Alzheimer's. It's not uncommon to see what is supposedly CBD oil being sold at gas stations and rest stops. If you see that, chances are you are probably, unless you're purchasing from a reputable source, what you're most likely buying is just coconut or olive oil. There are a couple other distinctions to know about if you're thinking about becoming a medical marijuana patient or thinking about suggesting it as an option to one of your patients. Based on the survivors and people living with cancer we talk to at events and on our hotline, doctors aren't always familiar with the different types of cannabis or cannabis products out there. I already mentioned on the previous slide that there are many different types of cannabinoids, with the two most common being CBD and THC. This distinction will be important to keep in mind when we talk about the laws governing cannabis access. The next distinction I want to mention is that while in the same family, there are two main types of cannabis plants, Indica and Sativa. These days, a lot of the marijuana on the market is a hybrid of the two. Indicas tend to have a more sedative effect, which might be better at nighttime, and sativas tend to have a more stimulating effect, which some people may prefer to use during the day. Depending on the symptoms you or your patients are experiencing, one strain might be preferable over another. In terms of toxicity, marijuana is far less dangerous than alcohol or tobacco. Around 50,000 people die each year from alcohol poisoning. Similarly, more than 400,000 deaths each year are attributed to tobacco smoking. By comparison, marijuana is non-toxic and cannot cause death by overdose. Side effects associated with cannabis are typically mild and are classified as low risk. Euphoric mood changes are among the most frequent side effects. However, cannabinoids can exacerbate schizophrenic psychosis in predisposed persons. And because of the tars and gases produced during the combustion process, smoked cannabis is toxic to airway tissue and probably also carcinogenic. So smoking is the least safe way of using it. Cannabis can have a marked but short-term effect on psychomotor performance, so driving-related tasks like reaction time. It can also affect attention and short-term memory performance, and can also induce dose-related short-term mental disturbances like anxiety, paranoia, feelings of unreality, distortions in perception. But those are generally short-term, and you can quickly recover from those. One other issue that we've heard about from time to time has to do with mold or fungus growing on the actual buds or flowers. And this can be problematic, especially for people who have compromised immune systems, but really for anyone. Obviously, breathing in something that has mold spores can lead to serious lung infections and chronic lung infections over time. So one way to potentially avoid that would be to seek an alternative way to use medical marijuana. So there's a number of reasons to look for alternative means of ingesting the THC or CBD that might help alleviate side effects of cancer treatment. So there's obviously always a possibility of harm if someone smokes marijuana on a regular basis, since smoking can be carcinogenic, and many people aren't able to smoke or just don't like it. So one option is to use a vaporizer. It's really the safest way to inhale the medicine because the oils are heated up, but nothing has to actually catch on fire. So it would limit the amount of tar or other chemical irritants you'd be inhaling. Another potentially safe way is to consume it via edibles or eating it. Cannabinoids are fat soluble, which means they dissolve in oil, butter, fat, and alcohol, but not water. It can be one of the safest ways, but dosing can be very difficult with edibles. So it's always recommended to be very, very careful. There's also the option to apply it via a topical medication. And then there's also a couple of synthetic cannabinoids on the market. So they are generally prescribed to people with cancer. So Marinol is one. It's a prescribed capsule. It's classified as a Schedule III drug. I'll talk a little bit about scheduling in a few slides. It's used to treat nausea and vomiting caused by chemotherapy and loss of appetite and weight loss in people who have who have AIDS. It's a synthetic version of THC suspended in sesame oil and does not contain CBD. Another option is Sativa, and it's a mouth spray to alleviate various symptoms of MS and cancer, including neuropathic pain, overactive bladder, and some other symptoms. Derived from 2 strains of cannabis, the principal active cannabinoid components are THC and CBD suspended in ethanol. So that's a mouth spray. Now that we know about the history about how cannabis has been used or is used, and its possible medicinal properties, let's turn to how it's treated under the law. One would think that a plant that offers so much potential for improving the quality of life for people with serious illnesses would be extensively studied, or at least somewhat available, considering the minimal risks and negative side effects associated. But as you know, that's not necessarily the case. When the Controlled Substances Act of 1970 was passed, cannabis was placed in the most restrictive category, Schedule I, which means that the federal government considers marijuana to have a high potential for abuse and no recognized medical use. It's important to note here that along with cannabis, heroin is also a Schedule I drug, while cocaine and methamphetamine are both Schedule II, which means that they have currently accepted medical use in the US or medical use with severe restrictions. The DEA, or Drug Enforcement Agency, has enforced the CSA, Controlled Substances Act, prohibition against marijuana use through criminal prosecutions, civil asset forfeiture, and other legal procedures. Since its founding in 1973, the DEA's mission has been to enforce the CSA and other drug regulations of the United States. Even in the early years of medical marijuana legalization, the DEA still routinely conducted raids of medical marijuana dispensaries and continues to work with local law enforcement to arrest hundreds of thousands of people in the U.S. each year for cannabis offenses. In October 2009, the Obama administration sent a memo to federal prosecutors encouraging them not to prosecute people who distribute marijuana for medical purposes in accordance with state law. The Cole memo outlined a series of guidelines that legalized states would follow to keep the federal government sort of off their backs. For example, keeping adolescents away from marijuana and ensuring that marijuana grow within a state didn't leave the state. In August 2013, the U.S. DOJ, Department of Justice, announced an update to their marijuana enforcement policy, because this was around the time that states actually started legalizing marijuana for recreational use. Essentially, they said that they would be deferring to those states to set up strong regulatory systems to ensure safety and compliance with state law. More recently, in January 2018, Attorney General Sessions issued a marijuana enforcement memorandum that rescinded the Cole menu, so took it back, and allows federal prosecutors to decide how to prioritize enforcement of federal marijuana laws. Specifically, the Sessions memorandum directs U.S. attorneys to weigh all relevant considerations, including federal law enforcement priorities set by the Attorney General, the seriousness of the crime, and the deterrent effect of criminal prosecution, and the cumulative impact of particular crimes on the community. So, while certainly there were some steps in one direction during the Obama administration, our current Attorney General has noted that, quote, good people don't use marijuana. That sounds a little bit unfair when we're talking about seriously ill Americans struggling to manage their cancer treatment side effects or effectively manage, for example, their child's uncontrolled epileptic seizures. The laws in the state marijuana laws are really rapidly changing. Even since I started putting together the slides for this webinar, another state, Oklahoma, passed a new medical marijuana law, and on July 1st, Vermont's recreational law went into effect. Just as with any other state laws, they can vary from state to state pretty significantly. So if you want details about how marijuana is treated in your state, please feel free to reach out to the CLRC or to review some of the resources I share at the end of the webinar. In some states, marijuana is legal for recreational use. In others, you have to have a doctor's recommendation to legally purchase marijuana, and in other states, only certain types of marijuana and marijuana products are legal. Many states only permit doctors to recommend medical marijuana to patients with specific medical conditions. The first state medical cannabis law was passed in 1996 by California Voter Initiative. As of July 2018, 31 states and the District of Columbia have passed laws legalizing to some degree the use of medical marijuana. However, when state law conflicts with federal law prevails. In constitutional law, this is known as the doctrine of preemption. So that means that in states that permit marijuana use, the agencies controlled by the states might, like the local police force, would potentially permit or sort of look away from people that are using marijuana in the manner allowed under state law, but that person would still potentially be considered guilty of violating federal law. In June 2005, the U.S. Supreme Court in Gonzalez versus Raich ruled that state medical cannabis laws do not provide protections for patients and providers from federal prosecution. So Currently, 13 states have decriminalized marijuana, but decriminalization just means that the penalties are lightened, so maybe a misdemeanor or a fine instead of a felony. Decriminalization laws vary from state to state. Some states attach fines to small amounts of marijuana, while others attach brief jail time. And whether a small amount means 10 or 100 grams depends on the state's laws. And in comparison, a marijuana joint weighs about half a gram. And this is compared to legalization, where possession and distribution are legal. States with CBD only, generally that's only approved for epilepsy or other seizure disorders that have not responded to other treatments. So here's a map that gives an overview of the status of marijuana laws nationwide. The dark green is adult and medical use regulated law, so recreational. Medium green is comprehensive medical marijuana laws. Light green is CBD or low THC product laws, and white, no marijuana access law at all. Keep in mind, even when decriminalized or available for recreational or medical use, there are often other restrictions, such as the quantity you can possess, where you can use it, how you can use it. For example, even though Arizona has a medical marijuana program, its Court of Appeals recently ruled that hashish, or the resin from the cannabis plant, is not covered by the law. Unfortunately, resin is what's usually used to make edibles, so this ruling has effectively criminalized the sale, possession, and consumption of medical marijuana products, although I assume that there will probably be some backlash over that. New regulations surrounding Oklahoma's medical marijuana program have banned smoking the plant and will require pharmacists to be at every dispensary. There's also been a lot of backlash about that lately. So as I said, these laws are changing pretty rapidly. And if you have questions about what's going on in your specific state, feel free to reach out to us. And it's always a good idea to reach out to your state legislators, since they're the ones that are potentially making these laws and regulations that might have an impact on your day-to-day life. Since medical marijuana laws are different in every state, you may have to follow a different procedure to obtain medical marijuana depending on where you live. If recreational marijuana is legal in your state, you can generally just take your ID to a local dispensary, fill out some paperwork, assuming you're over 21, and purchase what you'd like. The dispensary will charge you taxes, which are often earmarked for law enforcement, youth programs, education, and substance abuse treatment. If, on the other hand, you're looking to obtain medical marijuana, the process might be more complicated. In Conant v. Walters, the Ninth Circuit Court of Appeals held that the federal government could neither punish nor threaten a doctor merely for recommending the use of cannabis to a patient. This means physicians and other medical professionals may discuss the pros and cons of medical cannabis with any patient and recommend its use whenever appropriate. What physicians may not do is prescribe or provide cannabis directly to a patient or say where or how to obtain it. So in many states, you must follow several steps to obtain medical marijuana products. Generally, you first have to establish that you have a medical condition, such as nausea resulting from cancer, that cannot be managed effectively by traditional medicines and treatments. Then you must obtain a recommendation for medical marijuana from a doctor. Not all doctors make medical marijuana recommendations, so you may need to ask for a referral, or honestly, you might have to just Google it. In some states, you must then register with your state and pay a fee to receive a medical marijuana card, which will allow you to buy medical marijuana products from your local dispensaries. In some states, this card will also allow you to grow a small number of plants in your home if you want to. Keep in mind that in some states, the medical use rules are much more broad than others. For example, in Michigan, there is a specific list of conditions that would qualify you for medical marijuana, such as ALS, cancer, AIDS, hepatitis C, seizures, etc. and you may actually need to present medical records proving that you have one of those conditions. In other states, like California, the rules are a bit more lax and the categories of medical conditions are a bit more broad. So, the California rule says that you can have any debilitating illness where the medical use of marijuana has been deemed appropriate and has been recommended by a physician. Since medical marijuana is not formally prescribed by a doctor, you would not pick it up the same way you would pick up a normal prescription. Instead, you would most likely be required to go to a state-regulated store that sells medical marijuana products called a dispensary. Dispensaries often have armed security guards. Because your medical marijuana recommendation is just a recommendation, the doctor that provided you with the recommendation most likely did not prescribe or recommend a specific type of product or strain. That's where the bud tenders at the dispensaries come in. As you can likely tell from the name, a bud tender is more of a combination pharmacist and bartender who will likely be able to make some suggestions to you about which products or strains to try, depending on the side effects you're looking to minimize. Some of this is really subjective, and not all dispensary employees have the same information, so keep that in mind. Even if your state has legalized recreational or medical marijuana, it's still possible that it might be challenging for you to actually access it if there are no dispensaries near you. Some cities or municipalities have voted not to allow dispensaries within their limits or to limit the number of them in any given area. Some places have storefront dispensaries and others have delivery services or both. Oops. So before you dive into the world of medical marijuana, now that you have a little bit more information about how to access it and how it works, there are some important practical and legal considerations that you should keep in mind, especially if you are a person who drives, travels, or currently works or is looking for a new job. If you are traveling within your own state, consider the limits that your state law places on how much marijuana you can carry at one time and where, should the need arise, you can purchase more. In some states, like Massachusetts, you may possess up to a 60-day supply, which they say is 10 ounces, of marijuana at any one time. But in other states, the possession limit is as small as 1 ounce. But 1 ounce is a lot, and 10 ounces is a lot for a 60-day supply. So just putting that out there, it's really different depending on what state you live in. Just again, as an example, one marijuana cigarette or joint generally weighs about 0.5 grams. In some states, you may only register with and purchase marijuana from a single dispensary, whereas in other states, purchasing requirements are more flexible. You should carefully plan your travel to ensure that you comply with state law while maintaining a consistent pain or symptom management regimen. And of course, this should go without saying, but I will highlight this here. Driving while impaired, regardless of whether you have a medical marijuana ID card, is never allowed. There's no exception for lawful users of medical marijuana. And as an example, in California, a person is guilty of a DUI if he or she is driving under the influence of any alcoholic beverage or drug. So it's unlawful to drive under the influence of any drug. The state does have to show that the substance impaired the driver, not simply that the driver ingested the drug and subsequently drove, but still, it's not a good idea. It's very unsafe for both the driver and everyone else on the road. And it's illegal. Similarly, you should also be cautious traveling with marijuana from state to state by other means of transportation. In states where marijuana is illegal, you may be subject to criminal prosecution if you're observed to have marijuana in your possession, regardless of whether you possess any kind of medical marijuana recommendation or card. If you're considering bringing medical marijuana with you when traveling, keep in mind that under the Controlled Substances Act, it is a felony to transport marijuana across state lines. Furthermore, not all states allow dispensaries to honor medical marijuana cards from other states, so you may not be able to purchase more medical marijuana when traveling outside your home state. Sometimes people ask questions about, okay, well, what if I'm traveling from one state to another and both of those states have legalized marijuana? In those situations, technically speaking, you're still crossing state lines, so it still would potentially be illegal to do so. But most likely there aren't going, in practical terms, there are probably not going to be police officers waiting at the state border to try to, catch people doing that. Another area to watch out for, even within a legal state, is nearing any border crossing between countries. We're not even talking about actually crossing the border, but if you're entering the border crossing zone, that could also potentially get you into trouble. Flying with marijuana is illegal on any domestic or international flight because all airports, airplanes, and airspaces fall under the jurisdiction of federal law. The Transportation Security Administration, TSA, agents do not search for marijuana or other drugs during the screening process. However, if they observe that you have marijuana or other controlled substances in your possession, they will refer the matter to law enforcement. If the matter is referred to local or state law enforcement after you are caught trying to travel with it, you're unlikely to be prosecuted unless your state has passed additional laws prohibiting marijuana in airports. If the matter is referred to federal law enforcement after you're caught with medical marijuana in an airport, then you might face legal consequences. Additionally, when traveling internationally, consider, and it's already illegal to take it on an airplane, but it's also important to consider that other countries' law enforcement and legal systems may treat marijuana possession very differently, and in some cases much more severely than the United States. For example, when it comes to illegal substances, both Japanese law enforcement and the Japanese general public give marijuana the same harsh judgment as the country's #1 abused drug, methamphetamine. And even today, if foreigners are caught with any amount of marijuana in Japan, they can be deported with no chance to return. Since the most common questions we hear from our national hotline are about employment and rights at work, I wanted to make sure that I cover some information about how medical marijuana is treated in the workplace. Employers are allowed to maintain policies regarding drug-free workplaces, and understandably, most employers have rules about drug or alcohol use during the workday or on the premises. In most cases, an employee seeking first-time employment can be tested as a condition of employment, even if there's no cause or reason to believe that the prospective employee has been taking drugs. The employer, however, must test all incoming employees for drugs and may not single you out for special treatment. Some states have also imposed limitations on pre-employment drug testing. Most of the time, for drug testing after being hired, an employer requires reasonable suspicion before having an employee take a drug test. Even with the recent legalization of marijuana in some states, employees in those states can still potentially be punished for testing positive. The punishments for failed drug tests can include referral to an employee assistance program, rehabilitation, termination, and potentially the loss of unemployment benefits. Additionally, for those who have professional licenses like doctors, lawyers, and nurses, and other healthcare professionals, the take-home message is, generally speaking, if you want to protect your career, it's a good idea to avoid using marijuana, even if it's legal in your state, and even if you use it on your own time and off premises. It's still illegal under federal law. Generally, these types of professional licenses can't be revoked without due process through a disciplinary procedure before either a medical board or maybe the state bar. And it often isn't until their use rises to the level of a true substance abuse problem that you might face disciplinary action. But, generally speaking, it's better to be safe than sorry. The Americans with Disabilities Act protects employees with disabilities from discrimination by certain employers based on their disability. Under the ADA, employees with disabilities, like cancer, are also entitled to reasonable accommodations to help them perform their job more comfortably. These accommodations are usually negotiated with employers on a case-by-case basis. Examples of reasonable accommodations can include time off of work, working from home, temporary job reassignment, or possibly making exceptions to employer policies if these things would not cause the employer undue hardship. To be considered disabled under the ADA, you must have a physical or mental impairment that substantially limits one or more major life activities, have a history of a disability, or be a person who's regarded by others as having a disability. Since the ADA is federal law, it treats marijuana as an illegal drug, not a medication. Under the ADA, current illegal drug use is not protected as a disability, so medical marijuana use alone is not enough to entitle you to a reasonable accommodation in the workplace. Under the ADA, employers are not required to alter their drug-free workplace policies in order to accommodate a worker who uses medical marijuana, even if they are using it under a doctor's recommendation. No state or federal court has ever ruled that an employer must grant an employee's request to use medical marijuana during work as a reasonable accommodation. It is unlikely that a court would ever rule in favor of this accommodation because of marijuana's potential to impair an employee and due to marijuana's classification as a Schedule I drug under federal law. So clearly they wouldn't approve it for use during work, but this also goes to show that the ADA does not require employers to accommodate any sort of medical marijuana use if they have a drug-free workplace policy. Under state law, it's a little less clear whether employees with disabilities have a right to use medical marijuana outside of work hours. In most states, employers may terminate or refuse to hire medical marijuana users who fail drug tests. However, a few states have passed laws which explicitly protect medical marijuana users from being fired or otherwise disciplined for testing positive for marijuana use. Other states have also passed laws which indicate that medical marijuana users may be entitled to some degree of accommodation, though it is unclear what responsibilities employers would have in those circumstances. As a rule, while employees may enjoy some degree of protection for their actions outside of work, employers may always terminate employees for performance-related reasons, such as an impairment while in the workplace. If you believe that medical marijuana use would impact your job performance, or if you work at a job with a strict illegal drug use policy, you should consider whether other treatment options may be available to you. Some states have statutes with explicit language, either through anti-discrimination or reasonable accommodation provisions, providing varying levels of employment protection. These generally state that an employer cannot fire an employee based on the employee's status as a medical marijuana card holder or participation in a marijuana program. However, some states, such as Arizona, Delaware, and Minnesota, explicitly address drug testing and state that a positive drug test alone cannot automatically be a reason to refuse to hire or fire someone. Due to the rapidly changing nature of this area of law and the differences between states, I can't stress enough that it's a good idea to seek advice from an attorney in your area if you have questions. If you live in a state that has not legalized medical marijuana, do not attempt to obtain medical marijuana from an illegal source. Even if you're attempting to improve your quality of life by using marijuana instead of other prescription drugs, you may face severe criminal penalties. Instead, explore other treatment options with your doctor. There may be other medicines or therapies which may treat your condition or symptoms just as effectively. Alternatively, you may consider relocating to a state where it has been legalized if you and your doctor agree that medical marijuana would help provide you with the highest quality of life. And that pun was not intended. Additionally, be aware that if you are currently on other types of pain medication or have signed a pain management contract, testing positive for marijuana, regardless of whether you have a doctor's recommendation for it, may make it more difficult for you to continue to be prescribed your other pain medication. A pain medication agreement is a contract between a doctor and a patient. The goal of the agreement is to ensure that patients who are taking opioid drugs do so exactly as their doctor prescribed. In theory, these agreements are not only designed to protect the patient from drug abuse, but they also protect the doctor in case the patient abuses the medication in some way. For instance, if you do not follow the agreement or do something that is forbidden, your doctor may refuse to prescribe any additional pain medication for you. You could also be dismissed as a patient. And if you are dismissed, it can be much harder to find another doctor to take you as a patient and treat your condition. Generally speaking, medical marijuana. Oh, I just lost my microphone. Generally speaking, medical marijuana will not be covered by your insurance. Because marijuana is technically illegal and doctors are prohibited from actually prescribing it, there isn't a system set up that would allow insurance to cover the costs of cannabis products themselves. In general, private health insurance companies, as well as Medicare and Medicaid, are required by law to cover FDA-approved drugs. Since marijuana is not an FDA-approved drug, providers virtually are not allowed to cover it, even if they wanted to. However, depending on where you live and your health coverage situation, there may be some financial benefits that you can seek out. So for example, in California, the medical marijuana program provides voluntary medical marijuana identification cards for qualified patients and their caregivers. The fees for the medical marijuana ID cards are capped at $50 for Medi-Cal beneficiaries, where they are $100 for non-Medi-Cal patients. The program also provides for fee waivers for indigent patients or for participants in the county medical services program. If paying for your medication is an issue, there are a few other things that you can do. You can try to grow your own, take a class on how to grow your own medicine. If you access your medicine through a dispensary, sometimes there are discount cards or low-income programs, sliding scale programs, and just, as an example, an estimate of a typical family using CBD to treat childhood epilepsy spends about $1,800 per year on the substance. Despite increasing acceptance, there is little rigorous research on the benefits and harms of marijuana. Last year, a government-commissioned group concluded that the lack of scientific information about marijuana and CBD actually poses a risk to public health, the fact that we don't know enough. Recently, the FDA approved a medication called Epidiolex, the price of which has not yet been announced, to treat 2 rare forms of epilepsy in patients 2 years and older. But that's not quite medical marijuana. It's a strawberry-flavored syrup that has a purified form of CBD, which is intended to reduce seizures in some people with epilepsy. The process to conduct clinical trials or clinical research on medical marijuana or marijuana in general, is pretty complicated because the FDA has to review the application, then the DEA has to review the application by the researcher, and then the National Institute on Drug Abuse within the National Institute of Health has to provide the research-grade marijuana for the scientific study. The agency is responsible for overseeing the cultivation of marijuana for medical research and has contracted with the University of Mississippi to grow marijuana for research at a secure facility. So basically, all marijuana that is studied in trials comes from one specific source at the University of Mississippi. One last thing that I want to cover is the idea of right to try legislation, which was passed or signed on May 30th, 2018. This was in the news quite a bit, and right to try gives terminally ill patients the right to request to use experimental medications that have not yet been approved by the Food and Drug Administration. Some people who are less familiar with the details of the law actually rejoiced, posting on social media about how this meant that anyone would be able to try medical marijuana now. However, this isn't really the case, so I really wanted to clear up a couple of things. The law allows people to request medications that have made it through phase 1 clinical trials. This means that in order to be able to access medical cannabis through right to try, a patient would have to be gravely ill with a reasonable likelihood of dying within a matter of months, or have a condition that would likely lead to a severely premature death. A patient would also have to have exhausted approved treatment options and would have to be unable to access the treatment through a clinical trial. The only form of cannabis that has passed a phase 1 trial is Epidiolex, which is that drug that I just mentioned on the previous slide, which is intended to treat seizures and epilepsy in certain people. Right to try doesn't mean that you'll all of a sudden be able to grow your own plants or buy, possess, smoke, eat, etc. marijuana. The law doesn't actually give you any rights. It just gives you the right to request to use the right to request to use experimental medications. So we have several resources that you can look to if you have additional questions about marijuana in general or medical marijuana. NORML.org is a great resource, as is the National Conference of State Legislatures. We'll be posting, as I mentioned, we'll be posting the recording on our YouTube page, so feel free to check out these resources on your own time, and obviously you can reach out to the CLRC if you have additional questions about how medical marijuana is treated in your state. So I was able to leave a couple of minutes for questions. I'm happy to open it up right now if anyone has any, but right now I'm going to end the recording.